afternoon. My name is Jocelyn Nager. I'm the managing partner of Frank Goldstein & Nager. It's a law firm devoted to the collection of bad debt. Our practice is not only collecting bad debt, we teach clients how to prevent bad debt. We do so that this way, the debt that they do end up with will be more collectible and they will be in a better position financially to continue operating and to continue representation. We can continue representing them. What we'll do is we'll go into a client and we will evaluate their business process from sale through invoicing and through collection and find out exactly how they're doing business to find holes, possible holes, or defaults within their system to close up the gaps and to ensure that any holes will not result in an increase in receivables. So if someone is losing data or they're shipping without receiving the requisite deposit, right there you know that's a software problem and they need to close that up. Sometimes it's an issue where, actually Chris mentioned doing due diligence on your judgment. It could be an issue where the clients are not screening their clients properly and they're taking on claims or they're taking on clients that they really should not. They don't have the tolerance for risk that these accounts present. So you can actually work with any client that you might have and evaluate their process and procedure to help them streamline their efforts and decrease their receivables. We also will write credit and collection policies for our clients to help them have a work-through process so this way they're able to collect more debt in a shorter period of time. Many businesses, small and large, fail to incorporate all of the tools that are available to them to collect their debt. Software is terrific, having vendors set up, having staff in place, training, whatever they need, we can help them with. And then the third part of our practice is straight debt collection. And just Chris and Jim, we will take a case from the client walking in saying, hey, I'm owed some money and we'd like to collect it. We'll pick up the phone, we'll call, we'll send a written demand. Claims that are consumer claims are treated very differently than commercial claims. And if you're collecting debt, please make sure that you have different systems set up for consumer claims and a different setup for commercial claims, including your forms. Your forms should be different. And we'll hear more about that from Mr. Kaufman in a little bit. So debt collection can be very exciting. It's very exciting when you have a debtor call you on the phone and the debtor wants to make payment. I don't know how many of you have experienced that, but at some stage or any stage along the process, whether it's demand, the debtor says they'd like to pay, how would you like to pay? That's always the question we ask when someone calls on the phone. I received a letter, I received a phone call. We respond with, how would you like to pay? And based upon that conversation, that would determine what we're going to do next. So it is exciting. It could be when you've restrained a bank account. It could be when you've served a summons. It could be when you've served motion for summary judgment or discovery proceedings and the debtor, now defendant, has received a bill from his attorney or her attorney and they want to play let's make a deal. Because at the end of the day, they don't want to pay their attorney and pay your client or our client. We talked about a little bit, Jim discussed provisional remedies and order of attachment. And I just want to give you an example. I'm going to give you a couple of stories and examples of how these things come into play in collection practices. If you have questions as I go along, I will take questions and comments. So an order of attachment. I was brought into a client, actually it was my first appointment with a prospect, and the prospect owns a fuel company in Brooklyn. Took me months to get in to see him. I was very excited. I sit down and he tells me, let me tell you what's going on here, and of course that means there's something coming up. And what he had was a situation where he had sold fuel and maintained boilers for 12 different buildings, 11 or 12 different buildings in a complex. However, each building was a separate LLC, and you'll find that in your debt collection efforts that usually each building is a separate LLC. He learned through the grapevine that the buildings were going to be sold within 45 days, and looked at me and asked me, "What can you do for me?" Well, I sat there for a moment and tried to collect my thoughts, thinking, I can't even get the summons and complaint served and the affidavit of service filed within 45 days. By the time I end up with a judgment following the traditional manner, the buildings will be sold, there'll be nothing left in the LLCs to collect. So I told him, his name is Bill, and I said to Bill, I have an idea, I'm not sure that it's going to work, but what I think we can do is we can go in for an order of attachment. We can go in, give me the names of the buyers, let's prepare a request for preliminary injunction for an order of attachment. We'll prove your case in advance. We move by special proceeding and try to restrain monies that would be paid to his debtor customer at closing. So rather than the monies owed to Bill, rather than the monies being paid to the seller of the 12 LLCs, the monies would be paid to Bill. So that's exactly what we did. We made an application for an order of attachment. We had to name all the lienors. We named all the LLCs. We were able to find out the names of the purchasers, and it was a very close transaction. It was all within a religious community, so the people knew each other, and it was hush-hush. But Bill helped us to get the information, and we served about 20, 25 people. And once the judge signed off on the order of attachment and we served it by FedEx overnight mail, the debtor contacted our client, and within 48 hours, he wire transferred all the money into our client's account. Now, that's an example of how you can use a provisional remedy. They're not always successful, and I told my client, my prospective client at the time, that I wasn't sure it will work, but I think this is the best chance. So when you are handling debt collection, you need to be aware of all of the other tools that are available. And there are many tools available to collect a judgment. Another example would be a straight collection action, where we, of course, call the debtor, and we call the debtor, and he didn't want to make payment, and the client wanted immediate suit, so we served the summons and complaint. Very easy with e-filing. You can serve the summons and complaint right from the comfort of your office. Debtor was served, no response, no reply. We entered a judgment, and thankfully the judgment was entered rather quickly, which we'll talk about delays and all that in a little while. And we knew where the debtor's assets were. Our client was a subcontractor on a job at Columbia University, and he was working for a plumber. Our client is in STEAM. I do a lot of work in real estate in New York City. People selling to managing agents and not getting paid, or people working for GCs and not getting paid, or even the owner. In any event, we knew that the contractor was due additional monies from Columbia University, which is a major landlord and building owner in New York City. So we were able to take an information subpoena with restraining notice, and what we did was we served the legal department at Columbia University and the accounts payable. We served it in two separate offices just to make sure that we got the right party quickly. And the university restrained monies that were going to be paid to the plumber to satisfy our client's judgment. We didn't have to wait until Columbia dispersed the monies or send the marshal or sheriff to pick up the monies, because once the judgment debtor was notified that the account had been restrained, he arranged to send a wire transfer to our client for the full amount of the judgment. So often it's not the actual execution, and it's not the all of the tools that you'll have to use, but you'll need to pick and choose the correct tools to get the job done. Does anyone have experience with executions here? Positive experiences? Yes? Okay. I know we have an attorney here who works with the county in the back, so perhaps we'll, have some input from Ms. Arcuri in the back when she feels comfortable. Confessions of judgments, just briefly. I know Chris had mentioned confessions of judgment and why someone would want to execute a confession of judgment if they actually had the money. We have some clients that are not ready to refer claims to us for collections, but they have a situation where debtors owe them money and they're nervous. It could be a sizable amount for them, whatever that amount would be, and they're concerned that if the defendant, if the debtor does not make payments as promised, they'll be in a situation where they will have to litigate against their customer. Many are not fond of litigating against their customers, or they may have arbitration provisions in their contracts or mediation, and here's an opportunity where the debtor is coming to them and saying, okay, I can't afford to pay the whole thing, I do want to pay you, and at this time I'd like to offer a payout of X, Y, and Z. What we recommend to our client in those situations is to confirm it, get the debtor to sign a confession of judgment. So this way, in the event of a default, the client does not have to litigate, they don't have to arbitrate or mediate, they can then take this confession of judgment and they can file it with the county clerk and it will become an immediate judgment. Whether or not they have the money at that time is something to be seen, but the client has the strength at that point and they will actually thank you for offering this as a solution as opposed to trying to get the work into your office. And if you want to bill the client, bill them for an hour or two of time. If you want a side agreement, whatever you think the client needs. The confession of judgment is good for only 3 years. So if the payout is going to last past 3 years, make sure that you also prepare a separate agreement. Or in the agreement, in the company agreement, contain something in there that the debtor will execute a confession of judgment after 3 years for the remaining balance. Yes?
Sometimes you get a confession of judgment, am I right? Or even before any litigation.
Yes.
You're doing a deal and you feel a little uncomfortable.
Yes.
But if you have that and you're the creditor, you can't just take that confession of judgment and it becomes judgment. You have to litigate.
Absolutely not. The confession of judgment is a one-page document, and in the confession it contains the payment arrangement. So it could say, what's your name? I'm sorry. Phil. Phil could say that Phil agrees to pay $10,000 at the rate of $2,500 per month for 4 months on or before the 15th of each and every month. And in the event Phil fails to make payment, he agrees that judgment can be entered against him for the full sum of $10,000 plus interest at da-da-da, legal fees, whatever you're willing to confess, Phil. I will tell you though, be careful of the amount of interest that you use in your confession of judgment. Make sure that the interest is not higher than it should be, because then you could have a consumer claim and a Fair Debt Collection Practices Act claim filed against you, right, if it's an individual. So confessions of judgment are great.
Do you usually file the confession of judgment, or do you ever hold it in escrow as the debtor complies with the payment arrangement?
Okay, most of the time we will hold the confession of judgment in escrow. Right. The judgment debtor, the customer, the consumer, the judgment debtor, whoever it might be, is signing this as a way to avert litigation, arbitration, mediation, and most often they do not want the confession of judgment filed, especially if it's a public company or a consumer.
That's the whole point.
Yeah, well, it's a tool, and you can say, I'll keep it in escrow pending any sort of default.
And how do you word say you have a confession of judgment for $10,000 and the client says, or the debtor says, I'll pay $1,000 increments over a period of months, and it stops in the 5th month. Do you word your confession of judgment to say the balance of the amounts owed, or is it?
It depends on how you want to proceed. You can say for the full amount, less payments made to date. You can say for the full amount, credit given prior to execution. Also, again, I would watch whether or not it's a consumer case, because if it is a consumer case, you want to make sure to give your judgment debtor credit before you enter the judgment, right? The benefit of not allowing the debtor to receive a credit prior to the entry of judgment is really to maximize the interest that you're charging, so that New York has a legal rate of interest of 9%. If your judgment debtor owes $100,000 and has made payments of $90,000, leaving a balance of $10,000, you get much more interest on $100,000 at 9% than you do it at 9% on $10,000. So it depends. It's a call, and you have to see what your client wants and what the debtor will agree to, being fair to both parties. You want to support the client getting a confession of judgment.
Doesn't it also depend to some extent on what the contract between the client and his customer say, or this is all negotiated after the fact?
This is all negotiated. So if your client and the debtor have a contract whereby the debtor agrees to pay all costs of collection and interest, and you can use that as a bargaining tool, but at the end of the day, it is very difficult to get attorney's fees granted by the court. So if you have a debtor that's going to confess to judgment, you can include that in the body of the confession of judgment, that in the event of a default, the debtor agrees to pay the costs of collection. And again, we'll talk about that I'm sure later, the amount of attorney's fees can't be exorbitant either, because that could be considered a violation of the Fair Debt Collection Practices Act. So you have to be really careful, know who you're working with and what you can do. Confessions of judgments and judgments also, why would people sign that? You'd be surprised what people have in the bank. We have had cases against people where they have claimed to be penniless and ended up with a judgment, and you can find that they have millions of dollars in the bank. So there are some people that are very truthful. There are some people, especially today with medical debt being what it is, where they're first-time debtors and they're not sure how to navigate all of the debt. And then you have some people and some business owners that don't want to part with their money. If the money is in their pocket, they can invest, they can expand their business, and why pay you unless they have to? So there's all kinds of people in this world. Does anybody want to share a success story?
Yeah, one other thing I had recently is that when you do that, you should also have language in there that says that in the event of a default on the payment terms, that you could file it without notice to the debtor, and that you could docket it with the county clerk, execute on it without notice, because that just opens up another avenue for them to come back and try to contest it, that, they weren't giving notice, and then they'll file something just to delay it. So you gotta be careful with the wording.
That's a good
when
point.
you do that.
Let's see. Okay, does anyone want to share a success story before we move on? No? Okay. Phil, yeah.
Yeah, you had mentioned about negotiating attorney's fees and confession.
Yes.
But doesn't that, since that's really never some certain, doesn't that result in the possibility that you can't really enter the confession of judgment by the court, and now you have to take another step to go to court?
No. Your confession of judgment is for a specific amount. It's an agreed upon amount. So you can't say plus reasonable attorney's fees. You would state within the body of the confession plus attorney's fees of $2,500, or you would base it, yes. And the client's contract, if they have one, would provide for either a specific percentage for attorney's fees or reasonable. What's reasonable? Maybe 20% of the outstanding balance, right? Maybe 25%. It depends where you are. Yes, absolutely. So now moving on to executions and stuff, and if you are working within New York City or collecting debt in New York City or anywhere in the state, I would encourage you to become registered with the Department of Consumer Affairs. Get a DCA number, even if you don't think you're doing or handling consumer collections. Get the DCA number, and it should appear on your letterhead when you're dunning people. Okay, you may have a situation where you think you're dealing with someone who borrowed a loan, who took out a loan, right? They were a borrower on a loan, and they used the money for private purposes, personal reasons, as opposed to business reasons. They may have taken it as a business loan, but really it might have been a personal loan. So there are a lot of issues that can come up, so get your DCA number. I believe City of Buffalo has their own licensing requirements, so you might want to do that. before you do anything, make sure you have a valid judgment. We receive calls from actually debtors who have had their money taken by other debt collection attorneys, and they want to know what they can do to get their monies back. They may have satisfied a judgment, and then the judgment was then sold to a debt buyer. Debt buyer didn't realize that the judgment may have been satisfied. They have a portfolio. Take a look, do a lot of investigating, and make sure that your judgment that you're collecting on is valid. See who your defendant is, research it, as Chris mentioned, on the internet. Check public records. If you have Westlaw, you have a lot of information about liens and judgments, cases that perhaps the judgment debtor is involved in at this time. They may have an interest in a case, and you might be able to attach their interest in the case. You look like you want to ask a question.
It's comment. John Oliver, last week, tonight, did a segment just this past week about buying bad debt and satisfying it. It's very worth watching.
Okay, before you do anything, if you need to serve your judgment with notice of entry, please do that first. You want to serve judgment with notice of entry if there was ever an appearance by counsel. So if you were defendant appeared by counsel, or they were a pro se litigant, you are required to serve your judgment with notice of entry. Determine, again, whether you have a consumer or a commercial judgment debtor. If you have a consumer judgment debtor, I like to send my notice to judgment debtor immediately. I don't like to wait. I want to make sure that I've sent out my notice to judgment debtor and notify the debtor that I'm going to execute on the judgment. Some people don't like to do that. They're afraid the judgment debtor is going to go run and hide all his assets, but chances are he's hidden them already. So you're going to serve the notice to judgment debtor on the judgment debtor by mail. We actually put it in an envelope that's marked personal and confidential if it's on for a consumer, and we don't put the name of our firm, it's just the address, so this way it's not identifiable from a collection attorney. We are debt collectors, right, because we are in the business of collecting debt, so we are considered debt collectors and subject to all of the rules and regulations of New York City and the federal government. Serve it by regular mail. As Jim mentioned, you have to serve it a year before the service of the restraining notice. We do it at the same time. We're ready to execute on the judgment. We're sending out that notice to judgment debtor. If you don't send out the notice to judgment debtor, the restraining notice that you've sent out or the execution is ineffective. You've basically made a mistake. So imagine if you have a situation where your client tells you, okay, I have a copy of the check. I know the debtor banks at TD Bank. Hit the bank, I'm sure he's got a huge balance in the bank, and you don't send out notice to judgment debtor. Your bank subpoena goes out, your restraining notice, information subpoena with restraining notice. Turns out that the debtor did in fact have a huge account there, but you didn't serve the notice to JD, and you're going to explain that to the client. And all that work, and then what's going to happen. So make sure you do that, it's really important. Any questions so far? Yes.
The notice to judgment debtor doesn't apply in the commercial court if the defendant is a corporation. Right?
That is correct. That is correct. Make sure that your judgment debtor is in fact a corporation. So if your judgment debtor is doing business as Joe Smith Apparel, Inc., and then you, through your due diligence, you find that Joe Smith Apparel is not incorporated, it's really just Joe Smith doing business as Joe Smith Apparel, Inc., you're going to want to serve your notice to judgment debtor, right? Because it's an individual proprietor. Still an individual, even though it's a business context. People might disagree with me on that. For us, we're better safe than sorry. It's an extra document, and there's a lot of litigation, as you'll hear again from Mr. Kaufman in a little while. Better to be safe than sorry.
So that goes out before
We send it out when we're executing, right? You send it out first, and then you execute on your judgment. Yes?
What is the benefit of having a DCA number?
DCA number means that you're licensed in with the Department of Consumer Affairs, and you can collect debt within New York City.
But if I'm only collecting a debt, say, twice a year, I get a judgment from a court, and I'm saying, and I wanna issue a restraining notice, why do I need to register with the Department of Consumer Affairs?
If you're looking to levy on assets in New York City, or your judgment debtor is employed in New York City, or resides in New York City, or maintains a bank account within New York City, and you're going after it, you need to be licensed. You are a debt collector. If you are regularly engaged, and regularly engaged is subject to, it's really subject to discovery, you're a debt collector. You're a debt collector.
So you're saying it's a requirement in order to send a restraining notice, to have a DCA number?
It's a violation of statute if you are looking to execute on your judgment within New York City and you do not have a DCA number, you'll be in violation.
Is that true in as well as
No, just
So
consumer,
it's-
just consumer. But you'll see consumer and commercial intertwined much more than you think. Especially if you have a case where you're pursuing a corporation, and then whether it's real estate and you have a good guy guarantee, or you have a case against a sole proprietor, you have a loan, somebody is guaranteeing their credit line, you'd be surprised how often consumer,
That's considered consumer.
that's considered consumer. Okay, so let's talk about executions, and Jim did talk about executions, so I'm gonna talk about it from a practical standpoint, and if you have questions about executions, please let me know. It's gonna be in 3 parts. First is priority, then property executions, and income executions. Like a business, executing on a judgment should be done pursuant to a plan. You evaluate the judgment, you do due diligence on the claim, take a look at the internet, take a look at LinkedIn. If you have a commercial debtor, you want to make sure to investigate the debtor all over the internet. If you have a consumer debtor, I would stay away from social media sites. That might in fact be considered a violation of the Fair Debt Collection Practices Act and other federal statutes. So you need to be careful, especially if you're on LinkedIn or you're on Facebook. You know, when you look at someone, there's a, unless you're incognito, there's a way that your view of that person is tracked. So you want to go on the debtor's website. Let's talk about commercial claims so we're clear on that, right? You want to go on the debtor's website. Today, most people are proud to display the names of their best clients, right? That's easy, right? So if you have a judgment against someone, you can then go after their clients. You'll have testimonials. People have testimonials on their sites, right? They're getting testimonials. The authors of the testimonials have done business with the judgment debtor. They may have records where the judgment debtor remitted to them, and they would have banking information about the judgment debtor. So remittance check, that client who wrote the testimonial could contact their bank and get a copy and image of the check, and you would then know where the judgment debtor works, right? A vendor, a client. If it's someone that's in construction, you can see what jobs are open. You can see where they're working within the city or in the county. If it's a public job, that would be public information. So there's a lot of information out on the internet. Again, I had mentioned about cases, active cases. If your judgment debtor is a plaintiff or has an interest in the case, you'd want to pursue that as well as an avenue to recover. Most important thing is speed. You want to be the first one to collect, especially if there are a lot of parties that are pursuing the same judgment debtor. So you want to come up with a plan, and you want to, similar to a business plan, where you're going to attack in 5 or 6 different ways, and you want it all to meet in the perfect storm. Except that you don't want to put your judgment debtor out of business. So you need to know how much pressure to apply and when to let up a little bit, because the last thing you want to do is force this guy into bankruptcy, where your client will be one of many, or shut him down. And you can shut someone down if that's your goal. If your client is looking to shut their customer down, the debtor down, make sure you can take that case on an hourly, don't take it on a contingency fee. Anything that sounds like revenge, either stay away or ask for a nice non-contingent suit fee or an hourly fee, because your client will be very quick to spend your money and your time.
Get a nice retainer too.
Yeah. Yes, make sure your billings are up to date, which is a whole nother topic. You're going to assess the judgment debtor's fiscal health, same as Chris mentioned at the beginning of the case. Those are things you want to do throughout the case, right? So you don't want to carry a case from inception, from demand, and then through litigation or mediation and arbitration, and then litigation, as some clients have in their contract. You don't want to carry that case if in fact the judgment debtor goes out of business or the judgment debtor has tremendous liens. And you don't think that you'll be able to collect at the end of the day. You want to know when you can cut it off at the impasse. Let the client know it's done. You know, there's no reason to go forward and get yourself out of the case, and actually save the client a lot of time and money, because the clients spend time thinking about their cases, especially the smaller businesses. And they'll be relieved in some way. They'll be disappointed that you couldn't collect, but they'll actually be relieved that they can focus on something else. I want to go back to talking about selecting a marshal or a sheriff. Someone asked a question before as to, whose question was that? Want to ask the question again? Yes. How do you know when to select the sheriff or the marshal?
Right, and how does that work in general, the logistics of that?
Okay. The city marshal, New York City marshal, can collect a judgment that has been docketed in any of within the 5 boroughs. The judgment, the city marshal can collect a Supreme Court judgment where the judgment debtor has assets within the city of New York. Let's say my client has a judgment against a debtor who is out here, who's in Westchester, and the city marshal cannot levy in Westchester. That judgment has to go to the sheriff of Westchester County. We have had situations where the judgment debtor is in Westchester or a county upstate, and we, for whatever reason, choose not to send the execution to the sheriff. We will have the city marshal levy on a bank within the state, as long as the bank has a presence within the 5 boroughs. So this way we can levy on the bank quickly. The sheriff has a huge caseload, right? The marshal has a heavy caseload, but is also looking for a commission poundage on the recovery. So the marshal, and not to say anything bad against the sheriff, the marshal may be inclined to put some cases aside and act on something else that looks like it's a live case, similar to some collection attorneys. If you know it's a guaranteed payday, or if you have a special client and they want you to put this on the top burner, you're going to do that. So the marshal is also looking for a payday, because that's how he gets paid.
I guess that's what my question was here in Westchester, the sheriff is a Department of Public Safety official.
Yes.
He's an employee of the government, and he doesn't make more money or less money based on how quickly he helps you with your execution. And so what I guess I'm hearing you say is the marshal is a different animal.
Yes.
And can you just explain that a little bit?
Sure, it's the superior, can you talk about that?
Well,
About the sheriff?
Well, as you said, the marshal may have more of an incentive,
Yes.
because he's, it will be going to him rather than to the county general fund, as with the sheriff.
Yes. So when you send an execution to the city marshal, the marshal adds on 5% poundage plus statutory fees. So if you have a judgment for $100,000 and the marshal is making a levy upon the debtor based upon your execution, the marshal is going to make a demand for any post-judgment interest on that judgment, and that 9%, plus his poundage at 5% plus statutory fees. And the ticker goes up every day. Yes?
If I may, I think the easier answer is the city marshal gets to keep the overage as his profit, whereas the sheriff has to run all of the sheriff operations within the county.
Showing also, that's something you might wanna include in your engagement letter. That's something that we include in our engagement letter with our clients. Oh my gosh. We let them know, that, the marshal's entitled to 5% poundage, and that, it's the judgment debtor's responsibility to pay that. So this way, if the client contacts them directly, they should refer the delinquent client to our office or to the marshal's office, because otherwise the client might be on the hook to pay the 5% out of their pocket. So if the debtor calls the client directly and tries to bypass the marshal in our office, and the client says, okay, you know what, I'll take 90,000, no problem, just wire it in. Well, hello, you're responsible not only for our fees, the law firm fees, but you're also responsible for the poundage due to the marshal, plus the statutory fees, yes.
So if the debtor resides in Westchester and the judgment is in Westchester, but they work in New York City, then you have the city marshal execute in New York City?
You can. It's going to be a two-stage execution, and we'll talk about income executions in a few minutes. I'm just, generally these are property execution questions, because if that's working, income execution, we're talking now just about banks and brokerage accounts. Someone did ask about brokerage accounts before and how they're handled, very similarly to bank accounts. Yes.
There's a second question. Is there a requirement that I use the sheriff or the marshal?
No.
What? Yeah.
No. But you will see that you're going to need, in many cases, you will need the sheriff or the marshal. So let's say you've served your information subpoena with restraining notice, as Jim told us to do, and then the account is restrained. Well, if the judgment debtor calls you or emails you, lets you know, okay, you know what, I want to pay, you've restrained my account, I want to pay, you can then arrange for a direct release from the debtor's account at the bank. But you do have situations where the judgment debtor at that point still doesn't want to turn over the money, and in those cases you'll have to send out an execution to the sheriff or marshal to levy on the bank or the brokerage house and pick up the money. That goes as well for merchant accounts. So if you have a judgment against a business that accepts American Express or PayPal, Discover, whatever it might be, you can restrain the account, but you still have to pick up the monies using the marshal or the sheriff.
Where does that authority, where do you find it in the statute? The statute that says,
Executions.
it's in the CPLR?
Yeah.
And they talk about sheriff or marshal in that section of CPLR?
Yes.
Doesn't the other city also have sheriffs?
Yes. Sheriff is very busy too in New York City.
Do they have similar role with the marshal?
No, they're working for the government,
Okay.
right? And they do a lot of other things besides just enforcing judgments. So they're out impounding cars, and they're out with auctions, and they're doing a lot of other things, but they're extremely backed up as well, as is Nassau and Suffolk County. So the idea is, yes, use the sheriff or marshal to establish priority as a judgment creditor, but look for other ways to collect. Just don't rely upon the marshal or the sheriff to go out, especially the sheriff to go out, because you're one of many, and there are many judgment creditors, especially after 2008. The courts are flooded. Everyone's flooded with debt collection. Okay. I still love finding the debtor's best customers on the website. So how do you use that? Let's just talk about that for a second. So, what's your name? John. So John's client has a judgment against against the debtor for $50,000, and now John has to enforce the judgment. So John goes on to the debtor's website, and he sees that the debtor lists their best customers. And it turns out that many of these customers are in New York, or they have offices here in New York. So John would then take an information subpoena, and I always say with restraining notice. You can just send an information subpoena, but if you send an information subpoena without the restraining notice, you won't restrain anything that's on hand, and you want to restrain as quickly as possible. And John finds out that there's $45,000 due and owing to his judgment debtor. So John restrains that money, and then either the debtor will say, yes, okay, release the monies, or he has to send the marshal or sheriff to levy and pick up the monies. but the money's restrained, it's not gonna be paid out to the judgment debtor, it's gonna go to John's client's judgment, satisfy the judgment. Yes?
Aside from the legality, of it, what stops that client from kind of ignoring your subpoena? How would one know they just send out the money to the judgment debtor? They have a relation with him.
Right, they have a relationship with him, but they also should understand the legality of an information subpoena with restraining notice. And if you take it to the step of serving an information subpoena, which a subpoena DT on the bank to get bank records, that check from the vendor or from the customer is going to show up in the debtor's records, and you're going to know then that they violated the restraining notice, and then you could have a separate action against them as well if you can't collect the judgment.
You can ask the judgment debtor to bank for the actual, for his records.
Sure.
Oh, yeah.
Oh yes, that's huge. Are we covering that, or can I
No,
just
I
talk about
have a
that?
case right now where I have somebody who we just got a judgment for, and he says, oh, I didn't get any money, and the state, it was like a insurance claim, and we subpoenaed his insurance carrier, he put it with a casualty claim, property casualty, and the insurance company sent us copies of all the checks and the record, and then I went to his attorney, I was like, you might wanna see what you caught there. Yeah, let's send it to you.
So you can subpoena bank records, you
Yeah.
can get their bank statement, put down a time frame, you don't wanna ask for everything, it's probably not relevant, but absolutely, and that's really valid.
Yeah, so often when you serve an information subpoena with restraining notice on the bank, and you're asking for things that are outside of the scope of that document, the bank will respond and let you know they need a subpoena DT. If you find that the bank account was recently closed, you're going to want to get copies of the checks. You're going to want to see, or transfers, right, because you want to see where that money went. You want to follow the trail of the money. You could be following for a while, but you want to follow the trail, so you can get the cards, the opening documents. You can seal a safe deposit box. What can you do? You can get copies of the checks issued to the judgment debtor and checks issued from the judgment debtor to another party. You can get the statements. The statements are great, but really it's the check copies at the end of the day. And you don't want to ask for a volume of check copies. Sometimes just ask for statements, identify the checks that you're looking for that look suspicious to you, and then request copies of those, because you're going to pay for that.
Does that need to be so ordered? In general?
No, you can sign it from your office.
And the banks, my question is, the banks accept that?
Yeah, with a check for $15. That has to be served on the bank, though. You have to serve it as you would a summons and complaint. Yes?
Article 32, post-judgment subpoena on a third party. Do you think there's a requirement to serve a copy on debtor or debtor's prior counsel? Any notice requirement?
Well, you should serve a restraining notice on anyone that you believe might have, you would want to serve a restraining notice on the debtor themselves as well, prohibiting them from transferring any assets, right? Whether at the end of the day that's really an enforceable or that's just an exercise in futility, that's to be seen, but you would want to serve an information subpoena with restraining notice. You can serve a restraining notice on counsel, right? You can do that.
Back to the bank example, getting the loan application, copies of checks.
Yes.
In your experience, is there a requirement to serve that also on a copy on debtor or debtor's prior counsel?
No.
There's no requirement, it's actively, you might wanna do it for a whole host of reasons. And you might not wanna do it for other reasons, depends.
You might want to serve a subpoena, as we said, on the debtor's attorney, because he could be holding monies in escrow for the judgment debtor from other cases where he's represented the judgment debtor. There had been a sale of real estate, you might want to send an information subpoena with restraining notice on the attorney who handled the real estate deal. I mean, you can serve information subpoenas and restraining notices on many, many parties. But there's a cost to that as well, the time in the office, and also postage, and also make sure that you have sufficient costs up front and you have the personnel to do that. Yes.
I was, going back to your statement about going to the website and looking at testimonials. I was able to successfully collect a debt, last year just by telling the debtor's attorney, here's the list of your clients and other clients, and I won't disturb their business, we could just resolve this. And it worked.
We have a case, that's right, we have a case now where, case is about $270,000, and we made a motion for summary judgment. And it really ended up that we were granted partial summary judgment for about $213,000, and there's the balance remaining, the $67,000 or $77,000 that's remaining. And the judge refused to allow us to enter judgment on the partial summary judgment. They want to hold that part of the case until we resolve the remainder of the case. Because my plans were really to serve the information subpoenas, and actually the judgment would be against buildings in New York City where they have many, many tenants. So I knew that once I get a judgment, even partial summary judgment, I could serve the tenants and I could bring the whole case to a head. But you see what happened, the judge didn't want to do that. So we're trying to expedite judgment on the rest of it. Either that or the client would just have to forego the balance and say, I'm just going to go for the 217 or 220. Okay, so property executions, how do you do it? You're going to issue it from your own office. It's a form. I believe the form is in the book. There's a fee. Marshal's fee is $40. I think it's $40. The sheriffs vary by county. You need to contact the sheriff because I believe it's based on mileage. So contact the sheriff for property execution. The court can also prepare the property execution, but you can do it from your office. You don't need the court. It's valid for 60 days. Make sure that you extend your property execution after 60 days, or you'll lose priority. You'll have to start all over again, and whoever came in after you will go before you. So you want to make sure that you continue that property execution. You need to direct the marshal or the sheriff where to levy. You can't just send out a property, I mean you could send a property execution and tell the marshal or sheriff to levy, but it's helpful for you to direct the sheriff or marshal where to levy. Levy at the bank, levy at the brokerage account, levy at the customer, levy somewhere, because that will actually help you collect. Just a blanket levy, the marshal or sheriff will go to the debtor's place of business and make a demand, and sometimes that's successful and sometimes not. Because what if you have a judgment debtor corporation that's working outside of an apartment? Let's say they're working out of their home. Sheriff or marshal's not going into someone's apartment or home. They're not permitted to, so they're not going to be able to more than just post. They're not going to be able to do anything. They can't take an inventory of the computers and whatever's there. And more often than not today, most people are leasing their computers and they're leasing their equipment. So the judgment debtor may or may not own very much of anything in your office. So you have to find the assets. Yes?
Can the sheriff or marshal be used to execute on a federal judgment, or does it have to be a state court judgment?
You can use the marshal or the sheriff, but you have to reduce it to a state court
Can
judgment.
I just speak to that for a
Yes.
second? I had a case like that a couple of years ago. Rule 69 of the Federal Rules of Procedure allow you to use any state device as long as the judgment is entered in the district of a state in which you're using the device. I got a judgment, and I knew that they had a bank account and that there was money there, and I used the U.S. Marshals. And the U.S. Marshals are very good. I mean, really, really good. I mean, first of all, the whole poundage thing it's the minimus the amount of money that they get as the person that compared to a city marshal or a sheriff. And the second thing is that I sent my execution to the U.S. Marshals on a Tuesday, and by Wednesday, a couple of burly marshals had showed up at the bank with the thing. So the U.S. Marshals were actually very, very good. And my experience with that was much better than the typical state court scenario.
Yes, you can, definitely. Okay, I'm going to move on to income executions. Any questions about property executions? income executions. When to use an income execution? Use an income execution when you have a judgment debtor that's a natural person. So they must be receiving or will receive compensation for personal services. Could be wages, salary, commission, bonus, any source. But what happens when you have a judgment against a real estate broker, right? Real estate broker is not always receiving compensation in that form. Perhaps they're a 1099 vendor. Now, the statute, the C-Pillar provides for an income execution as it relates to that scenario, but we've never found that to be successful. We've always had to use a property execution with a 1099 vendor. The only thing that you might hit would be a bonus with an income execution or some additional commission. Okay, again, be sure consumer collections or guarantor of a commercial debt. I can't stress that enough. The judgment debtor on an income execution has to earn a certain amount of money. You can't just attach everyone and anyone's income. So there are standards that are set for part-time and for full-time, and the wages are being raised, you know. Income execution is one at a time, so it's first come, first served, right, for general judgments. If you have a judgment that's from custodial agreement or maintenance, that's something else, a divorce, a judgment. Someone had a question about judgment against, they're handling a case against a judgment against a former spouse that had been here in New York, and then the spouse moved out of state. So what can they do at that point? So that case would have to go actually to the state where the judgment debtor resides, because his assets are now in that state. His or her assets are in that state. So there's nothing left really to do in New York. You can take that judgment, you can convert that into a judgment in the debtor's state. Okay? Many times you will see, yes?
For garnishment, does the creditor get to, does the sheriff get to garnish, is it $150 a week is the minimum? Does the sheriff garnish between the $150 to the actual annual, or if the person is above the $150, the whole salary can be?
The whole salary can be excluded until that underlying debt is satisfied. So the maximum for an income execution, for your income execution to satisfy a judgment is 10% of disposable net income, right? Look, we've had a case against someone who's a waiter at the Hard Rock Cafe for the past 22 years, right? Still in business, so the income execution is still good. But the guy works on very little, minimum wage plus tips, and at the end of the day, we're still waiting. You don't really want, if you don't have a choice, then just go ahead with an income execution. Could be for a variety of reasons. Perhaps the pressure of an income execution will force the judgment debtor to come to the table and play let's make a deal. His employer perhaps, or her employer might not want an employee that has an income execution. But if you have a judgment and you're only going to see 10%, it's going to take a really long time to satisfy that judgment, and that your client is not going to be satisfied with receiving very small installment payments. And you're going to have to monitor the case for many, many years. So if you don't have anything else, yes, go with the income execution, put the pressure on with an income execution, but really look to satisfy your judgment using a lot of other tools and techniques. You don't want an annuity in someone that's working at the Hard Rock Cafe. So child support, government tax levies, and government student loans are given priority, and the wages, the judgment debtor's wages, can be garnished up to 25%. As I said, as I mentioned before, it's first come, first served. So if you are third in serving your income execution against the waiter at the Hard Rock Cafe, the three that are ahead of you are going to have to be satisfied before the marshal or sheriff can then go ahead and collect on yours. How does an income yes?
So does your claim then stay, or do you have to refile for
No,
income execution?
your claim will remain. or until the judgment debtor moves on to a different restaurant, right? Or a different job. How does it work?
Then you have to refile.
Then you have to refile, yeah. You have to refile and be the first one this time, right? Yeah. I mean, another way to do it would be really to get a copy of the check, if he's paid by check, or wire transfer information, find out how he's being paid, and then hit the bank and see what you come up with that way, right?
I think the problem you have with waiters generally is that all of their income, which is usually $4 an hour, is used to pay their tax obligations by the employer, which result the employer pays more. All those acts.
Well, that's gonna change soon, right?
Possible.
We'll see. Okay, so income execution works in, with two stages. The first stage is where you serve the judgment debtor at their residence. So if you have a judgment debtor that is working, this is aimed at you, within the city of New York, living within the city of New York, you would have to send it to a marshal or sheriff that can serve the judgment debtor at his place of residence, right? So it's first stage. So you send out an execution for first stage, and then if the judgment debtor does not comply, the second stage then is served on the employer. So it is possible to use two different sheriffs if you have a residence in Westchester and the debtor's working in New York City. Within the city of New York, then you'd have to serve first stage up here. Once it's sent back to you as uncollectibles, unsatisfied, you would then take that stamped unsatisfied income execution with a fee, and you send that to your other sheriff or marshal who can serve the place of business. Liens, right. Child support, we talked about child support, so you could wait if the judgment debtor's salary is being garnished 25%, you can wait until their child or children turn 18 or 20, depending upon the agreement, right? You have other issues that come up that arise when it comes to income executions. You have closely held companies, so you may have an individual who's running a corporation, right? He's the sole officer, he's the sole employee in the business, and he owes money, the company owes money, or he owes money personally, and there's an income execution that's served on him personally, he doesn't respond, then the income execution is served on the corporation. Well, he's not gonna honor, chances are he's not gonna honor that income execution, he's gonna make you do something, right? So the income execution will also come back unsatisfied, and then you would have to then move against the debtor corporation for failure to honor the income execution. Now, when do you do that and how do you do that? Because if your judgment debtor receives $500 a week in salary, you know that he earns $500 a week in salary, and your execution is not honored and it's been 3 months from now, let's say he earns $500 a month for ease, right? It hasn't been honored for 3 months, that's $1,500 that should have been remitted to satisfy or towards partial satisfaction of your income execution. You don't really want to make an application to the court for $1,500. You're going to want to wait a while, not too long, but you're going to want to wait a while, make a judgment, to allow some of the installments that were missed to build up. So it makes it worth your while to bring in a proceeding against the debtor corporation, the debtor's company, for failure to honor installment payments, to withhold installment payments. You had a question?
Yes, just going back to the first stage of the income execution
Yes.
procedure to serve the debtor.
Yes.
Do all of the provisions of the CPLR regarding the method of service apply, or is it restricted? You can't serve someone who lives in the department building, can you do substitute service? Can you do
It's the marshal or sheriff who's serving it.
Okay.
They're serving it. They know what to do.
Okay.
Yeah. Right. It's difficult to serve someone who lives in a doorman building. Yeah, but doorman service is good also, just as it relates to serving your underlying summons and complaint. Right? Yeah. Unrelated, but when you're serving a summons and complaint in a debt collection action, make sure to ask for a liquidated sum. You want to set that case up so this way you can get a default judgment without having to make a motion to the court. Very important. If you just ask for an amount approximate approximately an approximate amount or amount to be determined later on. You have to go through sometimes an inquest, a motion, an inquest, and you will delay entry of your judgment for maybe a year by doing that. Yes?
Do you have to send notice to the employer if you're sending the notice to the debtor? When is it the employer's obligation to send garnishment directly to the
When
clerk?
they're served by the marshal or sheriff with the income execution. So actions against the employer for accrued installments, unpaid accrued installments is C-Pillar 5231F. Allow them to accrue. I only have a few minutes left, so I'm going to just move on a little quickly. Just about levy, sale, and distribution of personal property. Jim mentioned what you can levy on and what you can't. And there are some things, a vehicle with that's worth $4,000. You can levy on bank accounts. Bank accounts are great. You can levy on brokerage accounts. I will tell you that there's an exemption when it comes to bank accounts, and the banks will allow the banks will apply an exemption. They're applying it for consumers and commercial judgment debtors at this point. So if you've restrained a bank account and there's $5,000 in the account, the bank will allow the debtor to safekeep about $3,000 in the account at this point, right? So you could have a smart, yeah, there's an exemption, bank exemption. Yes. Yeah, it's about 27 and change. I can give you the exact number, but it's about 27 and change. So when you have a judgment debtor that has a lot of time on their hands, they may open many small accounts. It depends. Everyone is different. If you truly have someone who is looking to hide their money, they can go around the city, at least in my neighborhood, they can go around and there's 50 banks within a mile radius. And they can open bank accounts at every bank, and this exemption could possibly apply at every bank. You could then, of course, make an application to the court if you were so inclined to say, hey, look what's going on. But we have not done that as of yet.
What's the purpose of the bank exemption?
Bank exemption is to give the judgment debtor some monies. The Bankruptcy Act does that as well. You know, the first, yes.
It actually arose because there was a mandate provision that monies earned from income should be garnishing, not attached to a bank attachment.
Right.
And that's where that arose from.
Right, and that's a whole separate avenue of relief for the judgment debtor. Let's say you've restrained a joint account, husband and wife, and it's and, it's not and or, it's not or. If you've restrained an account and it's John Smith and Jane Smith, if you have an and, you would then have to make an application to the court, a turnover proceeding, to the court saying you want that account turned over. It would be incumbent upon the judgment debtor, actually on the non-judgment debtor spouse, to show that more than half the monies in that account is theirs. Okay, but you would need to, the burden of proof is on the non-debtor co-owner of the account. When you serve an information subpoena and restraining notice on a bank, if there's a safe deposit box, the bank will seal the safe deposit box. Has anyone had experience with safe deposit box? Tell us. Was there anything in the box?
We didn't know because it was an attorney who owed a very long-standing debt. The court officers in New Jersey, once they received an execution, go out and find assets on their own. And this particular officer located the safe deposit box, which immediately, once the attorney was notified, called the court officer, paid the money to the court officer. However, there's a pending investigation and it's the court officer, so the money that was collected were paid into the court until a full audit is done of his books and records, because he's been accused of some malfeasance with reference to the money. But that was, our client was so amazed by that. So we don't know what was in that box. We just ventured to guess what the possibilities, what really was.
Wow.
That was really interesting, but we still don't have the money.
Wow. Well, years ago, I think twice, we actually had made an application to break open and empty a safe deposit box. So once you've sealed the box, you then have to go in for an application, go in for an order allowing you to break open and one point there were some coins, not much. There was coins in the safe deposit box. Another time the box was empty. So if you've sealed the safe deposit box, there's something in there, the judgment debtor knows. They may just do nothing, or they may say, hey, you know, I saw I have a judgment, not mention the safe deposit box, and try to play, let's make a deal. You know, people used to hide all kinds of things in boxes.
I'm sorry, I was just gonna say that.
That's okay.
I had one where the debtor had $30,000 in cash. So we had restrained the account, like you said, the bank sealed it, but the debtor claimed the exemption under 5222A, mailed the forms to the bank, that was in my office. So then we had a very narrow time frame to do the turnover proceeding. I think it was in Monroe County. So then after the debtor appeared and said that, you know, there was cash in there, but it was money he made, I don't know, from whatever exemption he said, the court had a hearing and decided to split the money. So instead of, even though it was BS, the court split the baby, but at least it was $15,000 from, that's very rare. In 20 years of doing this, never had a case like that.
Yes, and it is exciting, or can be exciting. You can sell with an execution shares of stock, vehicles, boats. In some cases you need a turnover. If it's shares in a co-op, you would need to make an application to have the shares transferred to the judgment creditor to satisfy the judgment. A vehicle, you know, think again about selling vehicles. What's the vehicle worth? Does the debtor lease the vehicle? You're gonna have to pay a lot of money to the sheriff to seize the vehicle, then it's gonna go to auction. You have to really, you know, all these things are great, but at the end of the day, look at what the possible recovery is gonna be for your client, because that's what you wanna do. You want a recovery. You don't wanna just do all this work and not end up with something to show for it. And especially if you're representing the client on an hourly basis, you tell them, oh, I sold the boat, it was a vessel, right? It's a vessel. And we sold the car and said, okay, well, how much am I getting? You say there's nothing left. The client is upset. So it's not, you don't want a one-off, you want a relationship. And managing expectations is key. Let the client know what you can and cannot do. Have the conversation in advance. Everyone's busy, but have the conversation in advance so you start off on the right foot with the client. Yes?
Can membership shares in an LLC be levied and you compel the sale?
I believe they can be.
You may be subject to the operating agreement of the LLC, which may prevent transfer of shares, you know, so I think in the circumstances, you have to look at what the operating agreement says. It may not be worth it to sell because you can't do anything.
On the other hand, doing that is a nice aggressive move, and making a judgment debtor sell.
I want to mention liens and docketing. We talked about docketing just for a moment. If you have a city court judgment or a lower court judgment, it could be civil court, city court judgment, in order to get a lien on real property, you're going to need to elevate that judgment to county clerk's office in that particular county. A city court, a lower court judgment does not put a lien on real property. So if you believe the judgment debtor owns real property, elevate that immediately. Docket a transcript in the same county. If you sued in Rockland County, in the city court in Rockland County, and your judgment debtor owns property in Orange County, but you sued in Rockland County because it was easier for your client or easier for you, you're going to have to then elevate that judgment to the county clerk in that county and then purchase a transcript and docket that in the other county, okay, in Orange County, from Rockland to Orange. You can't just go from the lower court and bypass the county clerk in that county. And that's a mistake some people make. Good news is an appeal does not stay execution of a judgment. Very important, because sometimes people will say, I'm going to appeal, and you're not going to be able to execute. Well, they can post a bond as security, right, for the full judgment amount, so eventually you'll get paid. But you can proceed. The appeal does not stay execution. A lien on real property is good for 10 years. You can extend it. A judgment is good for 20 years. Let's see. Let's talk about selling homes, right? Selling commercial property. Anyone have any questions? Yeah? Yes, Bill.
You mentioned about the ability to force a transfer of shares of stock in a co-op.
Yes.
Isn't that subject to what? Isn't that a restriction?
It may very well be. The board may right of first refusal, but you can bring the application. You would need to name the co-op as a party in interest. Yes.
That was, chapter 7, said bankruptcy, whatever bankruptcy, told the, lien period of money judgment with regard to real property.
I don't believe so. I don't believe so.
10 years with,
But you can extend the 10 years.
that's different.
Yeah. Commercial property, let's say your judgment debtor is a business and they own a building, right? They own a warehouse, they own a building. You can sell that. You can issue an execution to the sheriff or marshal and you can ask for sale of that commercial property. Fairly easy, right? Again, if your judgment debtor owns a building and there are tenants, you can restrain monies that are owed by the tenants to the debtor, and you can have those monies paid to you as judgment creditor, as attorney for the judgment creditor. You can make an application to sell a consumer debtor's home. We stopped doing that many, many years ago because of a lot of Fair Debt Collection Practices Act litigation, and really our clients didn't want to own the homes in the first place. We had a situation where the judgment debtor was married to their spouse and they were both alive. By asking to sell the interest, your judgment debtor's interest in the home, you were basically betting that the judgment debtor's spouse would die first and your judgment debtor would own the entire home, and then you could take the home. So it's really very tricky these days, and you'll hear more later on about Fair Debt Collection Practices Act and reporting and how careful you need to be as a collection attorney. How many of you are collection attorneys? Great. Okay. I think that's pretty much it. Any more questions? Yes?
With reference to executing against commercial real property in New York, is there any requirement that you have to demonstrate that you've exhausted all of the means to satisfy judgment against personal property?
Not that I'm aware of. No? Yes?
Does any of this change, in relation to debt buyers as opposed to the direct creditor?
There are a variety of laws that have been enacted for debt buyers, and actually practices to enter judgments, bring cases and enter judgments on behalf of debt buyers. It's a whole another practice in itself. My office does not represent debt buyers, and that's a decision that we made internally. It's just very tricky, and it takes a lot of work to enter a judgment, and there are mistakes, and there's a lot of work out there, and that's not work that I'm really interested in. Anything else? Yes.
Have you heard of a collection technique or ever used a collection technique called the bucket brigade? A personal injury attorney called me, and he was in possession of a large judgment which would have bankrupted the debtor, but for their insurance policy, which would pay out a small amount to pay off his claim in pieces. And once that claim was paid, the debtor would pay it over to the attorneys, and then the insurance company would replenish that amount and over a period of time, the entire judgment would get paid. And he was trying to explain this to me, and I'd never heard of it. And the whole point was to keep the debtor solid during a period when the insurance company was paying out the judgment. And just wondering if you've ever heard that, that's elaborate on that.
No, I've never heard that term, and thank you for letting me know. I'm going to write that down. We have had situations, though, where the debtor does not have assets to pay and the debtor is secured. So in this particular instance, the debtor is in the clothing manufacturing business, and they were financed by Samsung. So our judgment against the debtor was a very large judgment, could have put the judgment debtor out of business. Samsung was holding inventory and didn't want the judgment debtor to go out of business. So we basically worked out a deal with the debtor and Samsung whereby we would be paid in installment payments to keep the debtor afloat and enable him to pay. But the money was ultimately coming from Samsung, but it was money that should have been paid to the judgment debtor. Bucket Brigade, interesting.
Was limited to the amount of the insurance policy, they would only pay out a small lot, and only after the debtor paid out the claim. So they would pay the claim, the insurance would replenish the amount, the debtor would pay the claim, the insurance would replenish the amount to a certain point. And, I've never heard of anything that had it really
No.
that situation.
We've had cases where, we've sued on behalf of the client of the debtor's counterclaim, and the client brings in their professional liability carrier to defend, and as part of the universal settlement, the insurance company, the professional liability carrier, kicks in money towards the settlement, when considering how much they would need to bill and the value of the services they'll kick in as part of the settlement to settle the counterclaim. You're welcome. Thanks, everybody.